3 ways to not make your case in a motion to dismiss. One might surprise you. All right, great story for you out of the Southern District of New York. Hunley v. Buzzfeed. Plaintiffs bring this action for copyright infringement, alleging that Buzzfeed, defendant, displays on its website photographs taken from each of plaintiffs' Instagram accounts to generate profits and revenues. Plaintiffs seek statutory damages or, in the alternative, actual damages based on Buzzfeed's earnings resulting from the alleged infringement. Pending before the court is defendant's motion to dismiss. Following the death of George Floyd, each plaintiff took frontline photographs of the ensuing May and June 2020 protests in major cities in the United States and registered those photographs with the Copyright Office. Plaintiffs allege that BuzzFeed embedded and displayed at least one of each of their protest photographs from each of their Instagram accounts in an online post on the BuzzFeed News website entitled 17 Powerful Pictures of the Protests Through the Eyes of Black Photographers. Now, if you've been following this channel for a long time and you've really got a good handle on copyright, you might have already spotted the issue. We're going to look at it in a second, so this is no major spoiler here. But the title of the thing, just from the title, I can tell what the problem is. 17 Powerful Pictures of Protests Through the Eyes of Black Photographers. Well, what do we know about copyright and fair use? The secondary use, the fair use, has to be some kind of transformative. It has to use the minimum amount of the copyrighted work. It can't usurp the owners, the original owners, or in this case, photographers' market for the work. So if BuzzFeed has simply put 17 powerful pictures of the protest through the eyes of the photographers on a list, like we call them a listicle. It's not an article, it's a listicle. It's just a list. If it's just 17 photographs, as in like, hey, we collected 17 photographs without permission and then we put them on our website, that's not going to be fair use. But let's see what they did. Here is the exhibit. This is the article, 17 powerful pictures of the protests through the eyes of black photographers. And they write some prose here. They say, as protests over racism and police brutality sweep the nation following George Floyd's killing while in custody, pictures capturing heated moments during demonstrations have flooded our televisions. This is why BuzzFeed has brought together this collection of 17 black photojournalists who are on the front lines. One such photographer is Anthony Gaithers, who has been documenting the community he grew up in and offering personal insight, etc. Another is Chris Facey. This is the BuzzFeed article that they've written. And then here's the photographs. So was this paragraph enough to make it transformative? So Alyssa, Chris Facey, these are all very well done and powerful photographs, but the point was these photographs were not used with permission. They were used as a fair use. Let's see what the judge has to say about that and how right or wrong we are with our initial impressions about the fair use. This is a motion to dismiss, so the complaint must contain sufficient factual matter, not just speculation and conclusions. That factual matter gets to be accepted as true, so the judge is going to assume that the complaint is true as to its factual matter, and when taken as true, does it state a claim to relief that is plausible, not just possible, but is it plausible? And that, that's a difficult standard. If you've watched Mythbusters and you've had them, kind of call a tie where like they couldn't quite bust or confirm the myth, but it seems like they were on the right track, then it's just plausible. And there's really no super strict criteria for how you determine whether something is plausible or not. You get to argue it. So that's what we do here in the law, is argue possibility versus plausibility under the Bell Atlantic v. Twombly standard, a quintessential Supreme Court case from 2007. A claim is plausible on its face when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The plaintiff must allege sufficient facts to show more than a mere possibility. They say sheer here, but I think it's mere. More than a mere possibility that a defendant has acted unlawfully, and accordingly, where the plaintiff alleges facts that are merely consistent with a defendant's liability, that is short of the line between possibility and plausibility of entitlement to relief. In considering a motion to dismiss, the court accepts as true all factual allegations in the complaint, draws all reasonable inferences in plaintiff's favor. However, the court need not credit threadbare recitals of the elements of a cause of action. Duty, injury, breach, cause. Okay, I filed my lawsuit. Not good enough. Those are mere conclusory statements, or mere statements of the elements of a cause of action supported by mere conclusory statements. Instead, the complaint must provide factual allegations sufficient to give the defendant fair notice of what the claim is and the grounds upon which it rests. In addition to the factual allegations, the court may consider the documents attached to the complaint as exhibits and any documents incorporated in the complaint by reference. The court will first address Buzzfeed's fair use defense. The Copyright Act, under which plaintiff brings this suit, is intended to promote the progress of science and the useful arts. Under the U.S. Constitution, Article 1, Section 8, Clause 8, quote, by granting authors a limited monopoly over, and thus the opportunity to profit from, the dissemination of their original works of authorship, end quote. That's from Authors Guild v. Hathi Trust. But there are also limits upon creators' control over their own works, in particular, the doctrine of fair use, which allows the public to draw upon copyrighted materials without the permission of the copyright holder in certain circumstances. The fair use determination is an open-ended and context-sensitive inquiry. However, to sustain the potential future uses of artistic works, Congress has provided 4 non-exclusive factors that inform whether the given use is fair. The fair use of a copyrighted work for purposes such as, but not limited to, criticism, commentary, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work is a fair use, the facts to be considered shall be 1. The purpose and character of the use, 2. The nature of the copyrighted work, 3. The amount and substantiality of the portion used in relation to the original copyrighted work as a whole, and 4. The effect of the use upon the potential market for or value of the original copyrighted work. Fair use is an affirmative defense. The defendant bears the burden of showing that a given use is fair. Also, an affirmative use is when you admit you've committed the underlying factual acts, but that your what would be misconduct or violation of the law, copyright in this case, is exempted or accepted from the law by some exception or exemption, such as fair use. So an affirmative defense means you did the thing, but you have a defense under some exception. Courts have granted motions to dismiss infringement claims based on defendants' fair use defense when discovery of evidence would not provide any additional relevant information. And all that is necessary for the court to do is to make a determination as to the fair use of the 2 works at issue. However, as this court has previously observed, there is a dearth of cases granting such a motion. So fair use on a motion to dismiss, not the easiest thing to prove. Only some of our friends, like, what was it? The H3H3 Matt Haas case was a motion to dismiss, I think. The Aquila Hughes Sargon of Akkad case, I think, was a motion to dismiss. It's relatively rare. The heart of the fair use inquiry is the purpose and character of the use. The inquiry concerns the transformative nature of the work. It also concerns whether the use is of a commercial nature or for nonprofit educational purposes. The more transformative the new work, the less will be the significance of other factors like commercialism that may weigh against a finding of fair use. To determine whether the secondary use is transformative, the question is whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose, different character, altering the first with new expression, meaning, or message. Quote, a transformative use is one that communicates something new and different from the original, or expands its utility, thus serving copyright's overall objective of contributing to public knowledge. A secondary use can be transformative in function or purpose, even without altering or actually adding to the original work. That was the Aquila Hughes Carl Benjamin situation. He just edited her video and changed the title. BuzzFeed argues that its use of the photos was transformative, even though the photos were embedded from plaintiff's Instagram accounts on BuzzFeedNews.com without modification. The original headline for the post reads, 17 powerful pictures of the protest through the eyes of black photographers. Directly below the headline is a quote from a BuzzFeed editor that says, I want to make sure the stories of my fellow black brothers and sisters are accurately represented. The article in the post describes the protests sweeping the United States at the time following the killing of George Floyd. It stated that its purpose to bring together a collection of 17 black photojournalists to provide raw and unfiltered perspectives of these events as they unfold in real time. The article then very briefly introduces 2 of the photojournalists and requests that readers follow the photographers on Instagram. The Instagram photos from the photojournalists, including plaintiffs and others, are then displayed throughout the rest of the posts. Just in case you needed a reminder here, it's just these photographs. There's no other commentary, criticism. There's no one talking about the setting, lighting, framing, zoom, aperture. No one is commenting on the photographs. Drawing all reasonable inferences in favor of plaintiffs, the alleged use here is not transformative because the post fails to alter the photographs with new expression, meaning, and message. The court cites to the Dillon case where the use was transformative when pictures were taken to depict plaintiff in a positive light and then used as part of defendant's criticism and commentary on the plaintiff's politics. Unlike in Dillon, BuzzFeed merely uses the photographs to identify the photojournalists and makes no modification of the copyrighted material after embedding the photos. The post itself does not go beyond simply collecting photos and names of photojournalists, and it does not provide any altered expression or meaning to the allegedly infringed work beyond that for which it was originally created by the copyright holders. See the Nunes versus Caribbean International News Corp case. By using the photographs in conjunction with editorial commentary, the copyrighted work transformed into news and not into mere newsworthiness of the works themselves. At the motion to dismiss stage, drawing all reasonable inferences in plaintiff's favor, the court concludes that BuzzFeed's alleged use of the photographs was not transformative. The first factor therefore weighs against fair use. Because BuzzFeed failed to address the other 3 mandatory factors, it cannot sustain a fair use defense? What? Wait, so BuzzFeed did not provide a defense based on the other fair use factors. Let me just think about this for a second. So the nature of the works, okay, they're creative works, and BuzzFeed's articles are normally creative works. Second factor, I don't care about. Third factor is how much did you use? Well, they used the entire photographs. They used corner to corner the entire photograph from each photographer. So yeah, I can see why maybe BuzzFeed didn't put up a defense, because what would the defense be? But they filed this motion to dismiss, so they did mean to defend. If they knew they were wrong, they could have just settled the case rather than paying their attorneys in-house or otherwise. I don't know if their attorney is on retainer, in-house, salaried, or whether they pay them hourly to do this work. Couldn't that money have gone towards settling the case that seems pretty obvious if you're not going to defend beyond the first fair use factor? I don't know. That's weird to me. It's this weird to me, is what it is. Defendant, neither in its opening brief or reply, makes its case with respect to the other 3 mandatory factors. It is well settled that in raising the fair use defense, the statutory factors may not be treated in isolation from one another. All are to be explored, and the results are to be weighed together in light of the purposes of copyright. Defendants bear the burden of proving that their use was fair, and they need not establish that each of the factors was in their favor, but all the factors must be addressed. For this reason, the court finds that BuzzFeed has failed to state a fair use defense. Why? Why would you defend in a motion to dismiss and then not use the 4 factors? Like, that's why there's no point in defending. BuzzFeed raises 2 additional arguments. However, these arguments are without merit. First, they appear to raise factual disputes that are not appropriate at this stage of the case. At the pleading stage, the court accepts all factual allegations in the amended complaint as true. Now, this is not an accepting of the facts as true for the entirety of the case. It's just for the purposes of a motion to dismiss. Second, the additional arguments do not clearly go to any of the 4 fair use factors set out by Congress. As mentioned above, Buzzfeed is not entitled to a fair use defense at this stage where the first factor weighs against them and where they failed to address the other relevant factors for the defense. Drawing all reasonable inferences in favor of plaintiffs, the court finds no factual or legal basis to conclude that Buzzfeed's use was fair based on these arguments. Now, there is a footnote here, number 3. It says embedded photographs cannot be the subject of copyright infringement claims was their first challenge. So they're going to challenge based on the embedding. Somehow they had permission to embed because Instagram gives them permission to embed. Maybe. 2, plaintiffs granted Buzzfeed a license to use their work when they placed the photographs on their public Instagram accounts. We saw this with one of the Leibowitz cases, the wrong on so many levels Aaron Carl case with analytical grammar. Matthew Bradley had placed the photograph on Facebook, and Facebook's terms allowed anyone to use anything on Facebook for anything, really. It just said, by posting this, you're allowing anyone to make any use of your photograph. It didn't say on Facebook or through Facebook embedding. It just said, anyone, anything, go ahead, in so many words. So if that's the case with Instagram's license, which Instagram is Facebook and Facebook changed that term, so I'm going to assume that Instagram has a better embedding license, and we'll see. BuzzFeed could certainly have brought that license up here in a motion to dismiss stage and say, hey, we have a license, look at what the license said. But they didn't. It blows my mind. It inflates my ears that BuzzFeed did not defend themselves with those things at this stage. It makes me think, it makes me suspect, it makes me infer that BuzzFeed does not have that as a defense. Having determined that BuzzFeed has failed to establish a fair use defense at this stage, the court denies BuzzFeed's motion to dismiss. The court now turns to BuzzFeed's portion of the motion asking the court to sever plaintiffs from this action for misjoinder. Okay, so joinder is either permissive joinder or required joinder, and it's under Federal Rule Civil Procedure 19 and 20. And basically, you're allowed to join multiple defendants to one case, or multiple plaintiffs can join together in one case if they all stem from a similar cause of action and transaction or occurrence. The facts are going to be the same, the claims are going to be the same, the relief is going to be the same. They can all be joined. That's the short and slightly inaccurate version of joinder. So BuzzFeed's going to say that these plaintiffs cannot all join the same action, even though it was the same article and they all have the same copyright claim, and it's all going to be the same relief aside from maybe varying levels of damage. Under Rule 20A of the Federal Rules of Civil Procedure, persons may join in one action as plaintiffs if they assert any right to relief jointly, severally, or in the alternative, with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and any question of law or fact common to all plaintiffs will arise in the action. Failure to satisfy either prerequisite for permissive joinder constitutes misjoinder of parties. While misjoinder is not a ground for dismissing an action, the court may at any time add or drop a party. Plaintiffs bear the burden of demonstrating that their claims arise out of the same transaction or occurrence for joinder purposes. However, in assessing whether the requirements of Rule 20 are met, the courts must accept the factual allegations in a plaintiff's complaint as true. So we're still on the motion to dismiss standard. Courts in this district have used the Second Circuit's interpretation of Federal Rule of Civil Procedure 13A1A's transaction or occurrence language as guiding. District courts in this district have adopted a logical relationship test in analyzing transactions or occurrences under Rule 20. This test requires the court to assess the logical relationship between the claims and determine whether the essential facts of the various claims are so logically connected that considerations of judicial economy and fairness dictate that all issues be resolved in one lawsuit. Plaintiffs assert essential facts that are almost all logically related among them. Plaintiffs bring claims based on the use of their photographs in the same BuzzFeedNews.com post dated June 3rd, 2020. Each plaintiff has registered his or her photograph, all of which the same defendant, BuzzFeed, allegedly displayed on the same day without permission. The amended complaint also makes abundantly clear that there are common questions of law and fact among plaintiffs. Plaintiffs assert all the same factual allegations against the same defendant in support of their copyright claims. They also filed their opposition to the instant motion jointly, making the exact same arguments. So the opposition to the motion to dismiss was filed jointly as well. So they're working together. They've banded together as one team of enforcers, plaintiffs, prosecutors, if you will. Even if a joinder is proper, the court may still sever at its discretion. Courts acknowledge that this is a procedural device to be employed in exceptional circumstances, and the moving party bears the burden of demonstrating that severance is required to avoid prejudice or confusion and to promote the ends of justice. In addition to the considerations under Rule 20, a decision to sever under Rule 21 examines 3 supplementary factors. 1, whether settlement of the claims or judicial economy would be facilitated. 2, whether prejudice would be avoided if severance were granted. And 3, whether different witnesses and documentary proof are required for the separate claims. Given this early stage of the litigation, to promote judicial economy and for purposes of streamlining discovery and possible settlement, the court sees no compelling reason why BuzzFeed would face prejudice or confusion if BuzzFeed's severance request is denied. Therefore, the court declines to sever any of the plaintiffs from this case. BuzzFeed also made a motion to strike. Under Federal Rule of Civil Procedure 12F, the court may strike from a pleading any redundant, immaterial, impertinent, or scandalous matter. The motion must state with particularity the grounds for seeking such an order. The motion to strike must be precise. To prevail on a motion to strike, a party must demonstrate 1, that no evidence in support of the allegations would be admissible, 2, that the allegations have no bearing on the issues in the case, 3, that to permit the allegations to stand would result in prejudice to the movant. Courts should not tamper with the pleadings unless there is a strong reason for so doing. At this early stage in the case, the court does not have a strong reason to tamper with the complaint by striking the disputed allegations as impertinent, irrelevant, or immaterial. It is too early in the litigation for anyone, including BuzzFeed, to know whether the disputed allegations would be admissible at trial or would have absolutely no bearing on the issues in the case. Evidentiary questions should be especially avoided at such a preliminary stage of the proceedings. Usually the questions of relevancy and admissibility in general require the context of an ongoing and unfolding trial in which to be properly decided. And ordinarily a court should not decide to strike a portion of the complaint on the grounds that the material could not possibly be relevant on the sterile field of the pleadings alone. So in other words, we're too early. The court wants to build the record a little bit more, wants the parties to have the discovery of evidence and then decide whether there's a motion to dismiss or motion for summary judgment or something else, or a trial, I guess. In addition, the amended complaint sets forth allegations that appear to provide a better understanding of the claim for relief by providing background facts, and thus are proper. Matters should be stricken on the basis of impertinence only where the allegation bears no possible relation to the subject matter of the litigation. At this time, the court is not convinced that BuzzFeed will suffer any prejudice if the disputed allegations remain in the complaint. For the following reasons, BuzzFeed's motion to dismiss or sever or strike the plaintiff's allegations is denied. The court encourages the parties to discuss settlement. Yeah, I am not sure why BuzzFeed even chose to defend this. It seems like such an open and shut case. And then they chose to file a motion to dismiss, but then they didn't file any defense for the second, third, and fourth fair use factors. So they pretty much open and shut, hands down, lost the motion to dismiss. The motion to strike doesn't seem to be anything at all. And the motion to sever was based on a half-hearted defense of improper joinder, which the grounds didn't really exist because It's the same series of photographs in the same article. The cause of action arises out of the same injury, the same article, the same internet post. So what was the ground to try and sever? I don't get it. Why not just settle the case? Anyway, let me know what you think of that in the comments below. So one of our viewers sent this in: Instagram just threw users of its embedding API under the bus. People may need to get permission before embedding someone else's Instagram photo. If that is true, then the Buzzfeed embedding is not automatically permissible. So that will become part of the lawsuit. If I see anything else here, I'll add it in. But thank you, Harrod, for sending that in. And that's our show. Thank you for watching. Special thanks to our top supporters in October: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench and sponsus.com/law, or through YouTube memberships and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.